He relies on Marbury's oft-quoted statement that a president's official acts, quote, can never be examinable by the courts, end quote. Id, quoting Marbury 5 U.S. 1 Cranch at 166. See also Reply Brief 6. Former President Trump misreads Marbury and its progeny. Properly understood, the separation of powers doctrine may immunize lawful discretionary acts, but does not bar the federal criminal prosecution of a former president for every official act. Marbury distinguished between two kinds of official acts: discretionary and ministerial. As to the first category, Chief Justice Marshall recognized that, quote, the president is invested with certain important political powers in the exercise of which he is to use his own discretion and is accountable only to his country in his political character and to his own conscience, end quote. Marbury 5 U.S. 1 Cranch at 165 Tech 66. When the president or his appointed officers exercise discretionary authority, quote, the subjects are political, end quote, and, quote, the decision of the executive is conclusive, end quote. Id at 166, their discretionary acts, therefore, quote, can never be examinable by the courts, end quote. Id, quote, but, end quote, Chief Justice Marshall continued, quote, when the legislature proceeds to impose on that officer other duties, when he is directed preemptorily to perform certain acts, when the rights of the individuals are dependent on the performance of those acts, he is, so far, the officer of the law, is amenable to the laws for his conduct, and cannot, at his discretion, sport away the vested rights of others. End quote. Id, emphasis added. Under these circumstances, an executive officer acts as a quote ministerial officer, compelled to do his duty, and if he refuses, is liable to indictment. End quote. Id at 150. See id at 149 Tech 50. Quote, it is not consistent with the policy of our political institutions or the manners of the citizens of the United States that any ministerial officer having public duties to perform should be,